saying, it's surprising how many otherwise competent attorneys punt at the sentencing hearing. Judge Scalia suggested that attorneys take a page out of the book from their death penalty colleagues and advise, don't wait to think about sentencing advocacy, because 99% of one's federal criminal clients will be facing sentencing, and so start preparing for the case as early as you can. And I know all of you who are tuning in know someone or personally going through this experience today. No one can promise you and say that, I know the judge, don't worry. There's no rush to prepare. You've heard that the feds were asking questions, but still you're told there's no rush. With a broad brush, a satellite view, the stages are, you may hear that there's rumors that the FBI and the Department of Justice have been asking questions. You may have gotten a target letter or someone showed up at your home. Your defense. What you can do is different than what your attorneys can do. The nuances of everything that goes into a federal criminal defense is not just on the legal side, because the judge knows nothing about you. Your attorney knows nothing about you. So it starts with a well-written personal narrative. This is your story or your autobiography or your brand. Wheaties has Breakfast of Champions. Nike has Just Do It. Tesla's got SpaceX. But why do you want to write your personal narrative? Because the Department of Justice has gifted you and printed their story of you. It's called your indictment, where you appear as America's most wanted, and it's likely not that flattering. The pre-sentence interview and investigation process. Your personal narrative, you need to prepare well written. It'll take a couple months. Getting all your files to your attorney, and then from your attorney to the probation officer about a week before your interview, comprehensive and organized, it may be appreciated, because they will then have the time to fill out their probation report worksheet. And then when they meet with you at the interview, they can personally get to know who you are and ask any remaining questions that you may have. That's because many reasons. For the first is that your probation officer is allowed to make your sentence and placement recommendation to the judge before you ever get there. Second is that your judge is going to read your pre-sentence report before you go into court. So they'll probably already have a sentence in mind. If you don't have a personal narrative and release plan woven into and attached to your pre-sentence report, then all the judge is going to read is your pre-sentence report and your indictment. And good luck with that. And they're going to be ready for someone who's, appears to be a career criminal. My name is Dr. Marc Blatstein. How I became a physician prison consultant. Welcome, my name is Marc Blatstein. After 30 years in patient care, this experience has provided me with the professional expertise and practical insight in preparing you for the pre-sentence interview. This interview is the most important and overlooked phase of the federal sentencing process. It will determine your entire future. While no one can give you any guarantees, preparation can humanize you to your judge, because without preparing, your judge is going to just sentence you based on your indictment, where you may appear as America's most wanted, which we all agree you're not. It may reduce your sentence, provide options for a diversion type of sentence, allow for a specific federal prison placement request, provide you with the early release opportunities, and reduce the fears that you and your family and loved ones are naturally experiencing. If you have any questions regarding the federal sentencing or just in general, give me a call at no charge, 240-888-7778. Article regarding Judge CARLTON REEVES' order granting qualified immunity. And it's my own overview. I'm not an attorney, but my take on it is when qualified immunity is abused. And so let's start. The Constitution says, and I'm looking over here to my right because I'm reading my notes. The Constitution says everyone is entitled to equal protection under the law, even at the hands of law enforcement. Over the decades, though, judges have expanded legal doctrine to protect law enforcement officers from being held accountable for their actions. The resulting doctrine, called qualified immunity, has not just evolved, but morphed into absolute immunity, a transformation that underscores the gravity of the situation. This has left judges with few, if any, viable options, a stark reality that underscores the urgent need for change. See here? This story starts with a man, Jameson, driving his new Mercedes-Benz CLK class convertible, which he has purchased 13 days before from a car dealer in Pennsylvania, driving it to his home in South Carolina. The journey takes him through Mississippi. Now, Jameson, he didn't look like a suspicious person. He didn't make an improper lane change. Further, Jameson wasn't suspected of passing counterfeit $20 bills. He wasn't mentally ill and in need of help. He wasn't walking back from a restaurant. He wasn't standing outside of his apartment or home. He wasn't sleeping in a bed. He wasn't driving over the speed limit. Now Jameson was just a black man driving his new Mercedes convertible. His mistake was being a black man and being in the wrong place at the wrong time. The following came from Officer McClanahan's testimony. The officer says he stopped Jameson because the temporary tag on his car was folded over where he couldn't see it. It must have been held, he said, with only 2 bolts. But with his testimony at a later date, it was seen that there was actually 4 bolts holding it. The officer asked Jameson for his license, insurance, and the paperwork on the vehicle because he says it didn't have a tag. Again, in the testimony later, it was seen that the tag was there being held by 4 bolts. Jameson provided all of this and the bill of sale and the insurance, as well as his South Carolina license. Officer McClendon's background check using El Paso Intelligence Center, EPIC, the National Criminal Information Center, NCIC, as well as Jameson's criminal history check and the VIN check of his car, all came back clear without any problems. And yet, the officer did not let Jameson know this. Next came the lies and intimidation by the officer. The officer asked Jameson if he could search his car multiple times. And it started off with Jameson asking for what? To search for illegal narcotics, weapons, large amounts of money, and anything illegal. The first request for a search. And when asked why, the officer changes the conversation to what kind of work do you do? And Jameson said he's a welder. The second request for the search, Officer McClanahan said he received a phone call reporting that there were 10 kilos of cocaine in Jameson's car. Well, that was a lie. And Jameson said no. The third request for a search came and went. The fourth claim for the search, the officer said, come on, man, let me search your car. Jameson said no. The fifth request for the search, I need to search your car because I got this phone call about 10 kilos of cocaine in your car. Jameson kept telling the officer there was nothing in the car, and the officer refused to listen. Officer McClanahan continued to bring up the 10 kilos of cocaine, asserting the car was stolen when he knew it wasn't. Asked Jameson how many vehicles he owned. Claimed that Jameson did not have car insurance on the car when he knew that was false. Jameson finally gave up. He told the officer McClellan, as long as I can see what you're doing, you could search the vehicle. The officer then proceeded to search Jameson's car from the engine compartment to the trunk to the undercarriage to underneath the engine to the back seats to anywhere to account for all voids inside the vehicle. In his deposition, he did not find anything suspicious whatsoever, and the canine search dog gave no indication confirming there was nothing in the vehicle. In the total amount of time for this stop for Jameson by the side of the road at nighttime was 1 hour and 50 minutes. And it was probably very stressing for this young man to be there with an officer with a gun and him being a black man. This occupied pages 1 to 14 of the order. Pages 14 to 17
is the legal part, and I'm not an attorney. But in the end, because of the illegal, because of the qualified immunity regulations, the judge was obligated to grant qualified immunity, but he also said that this matter will be set for trial in due course. So it is in this order's humble opinion or mine that the common sense interpretation of qualified immunity in some cases appears to me that it needs to be revisited and rewritten. I hope you have found this helpful. I appreciate you taking the time to listen to this YouTube today, and I hope you all have a good day. Take care and stay safe.